Hi, my name is Christine Pearl Princesa. I'm going to report about the corporate codes and unfair trading behavior, the role of unfair commercial practices law. Unfair trade practice in general is refers to using various deceptive and unethical methods to obtain business or trade practices which for the purpose of promoting any sale or supply of any goods or services adopts unfair method. All right, so let's go with the topic. Let's tackle for this tackle first the comparative approach for this. So the comparative approach is the harmonious relationship between the nature, a national law and the European law with regards to the unfair commercial practices. So the implementations of these directives may vary and produce different outcomes due to different regulatory characters, naming German and English system. So it's these two different systems. The German system is or more focused on the self-regulatory codes, which is for them is cost efficient, speedy, and cooperative. And it is implemented by the Committee of Advertising Practice, which is the CAP. All right, so let's go to the scope of unfair commercial practices law. The first one would be the setting the scene. This is with regards to the working conditions or physical working conditions of the factories or the working place of the organizations or the corporations. The very famous example of this one is the Kasky versus Nike issue that was happening in 1990s. What happened was there was an public outcry with regards to the working conditions of the foreign suppliers' factories, and then after that, Nike made a public statement with regards to that issue that they are now improving or working on improving the working conditions of the subjects. However, after the investigations made by the critics, they found out that there was no improvement made and there was no changes. So Kasky made a file claiming that Nike is misleading the consumer in their public statement or in their what they said with regards to the working conditions and the exploitations of workers. So that was what happened. So that is the very specific example of this one, the setting of the scene. So this is with regards to the physical conditions of the working areas. And the next one would be the environmental and social content of corporate codes. Product flyer or the likes contain false information about the nature of the trader, nature of the product, or the extent of traders' commitments. This is pertaining to the environmental claims. For example, products or companies having environmental claims about their products or um, services, and that is false or dishonest. So it will fall into this category. And then this category as well, um, highlighting Article 6.2b on the of UCPD, that is the non-compliance with the code of conduct will be viewed as unfair commercial practice. All right, the third one is the regulating communication and corporate codes. So this is with regards to the statements in advertising, such as we do not contract with factories that employ children. Those are examples of uncontroversial statements that if um, afterwards investigated and found out that it was false or there are relate a relationship with the claims and the actual process, it will going to falls under this code. The publication of false information will be viewed as unfair commercial practice. All right. The fourth one is the communication on process and corporate performance. So this is particularly specified with the respect to the environment, which environmental claims should be clear, truthful, and accurate and not misleading. So there are two principles to implementations that would be a guidance or a standard for this one. Those are one, it should be specific, accurate, and unambiguous manner. And the second one would be the trader must have a scientific support to claims and should be available if claim is challenged. So it should have just a scientific justification of the claims, and it should be available all the time. All right. The next one is the communication and social and environmental engagement. So aside from companies making monies, it's also it should be the companies should be taking an active role in the society. And under this category, codes do not directly link to the company's product. So it's only a commitment to initiate a change that can improve the working conditions and environmental pollution problems if necessary. So what does it mean is that the code are not directly linked to the company's product. It's not pertaining to the product, but a guidance to initiate a change of improvement. And the product advertisement should be separated to general statements that is specified in this category. All right, let's go to the interim conclusion. Unfairness of particular code could be determined on an individual basis with a view of particular code, or a particular code is likely to be misleading. All right, so the unfairness of particular code could only be determined on an individual basis. What this means is that there are no standard basis or standard rules or something like that to categorize or determine the code would be an unfair. It will always goes down to individual basis or depending on the situations. All right. Second would be corporate code could qualify as unfair commercial practice if it contains objectively false information on actual performance and product of the company. So it's already understandable. All right. So taking a little case further, it's about regulating non-compliance with a corporate code. So you can apply unfair commercial practice law if the use of corporate codes are used in marketing tool. Second, inaccurate, misleading, and incomplete use of its code commitment. And the third one is an actual non-compliance of the codes of conduct would be falls under the unfair commercial practice. All right. So the codes of conduct in European unfair commercial practice law. So what is this? These are self-regulations as complementary measures in the field of consumer protection. So this is what it's about. Behavior of trader bound by the code in relation to one or more particular commercial practice. So the behavior of trader is bound or guided by the code. And the set of rules are not imposed by law that required pursuant Article 6 UCPD, that the first code is not aspirational but firm and capable of being verified. Second, the company has to indicate in a commercial practice that is bound by the code. And third, that the commercial practice is likely to mislead the average consumer. All right, conclusion. Two possible options to approach the codes. There are two possible options, and the current regulatory focus in unfair trade law is the regulation of corporate code communication, or as I said a while ago, it's about the clear statements and the not misleading statements. It should be precise, accurate, and truth. Also, adding to the narrative is the non-compliance we're likely to take as unfair commercial practice, and the use of self-regulatory codes for specifying fairness standard. Question: is it primarily the communication and the code and the use of the code in the marketing that ought to be regulated as potentially misleading provision of information? And if so, how far should the scope of unfair commercial practices law in terms of regulated communication reach? Or is it rather the non-complying behavior that ought to be focus of the regulations? These are some of the guiding questions that is not yet answered and can be answered in the following reports. All right, there are applicable remedies. These applicable remedies are only focused on the reinforcement mechanism in case of non-compliance with a corporate code would result in a liability for the committal of the unfair commercial practice. So the limitation of this is only about the non-compliance with the corporate codes that is resulting to liability for the committal. All right, the first one would be the collective enforcement procedure in case of breach of duty to deal with it fairly and in the injunction order. So there are two laws for this. English law, known as the administrative procedure by which consumer have the right to seek injunction orders against trader committing an unfair commercial practice. And the second would be the German law. It's a legal action in the civil courts that can be initiated by private associations. In order to qualify for the institution, they have to be on the list that is set and frequently updated by the Federal Office of Justice. So there are a lot of like things um, before you can qualify for this action for the on the German law. And the second one would be individual enforcement. It is individuals and companies are entitled to remedy a violation of fair trading laws, provided they are negatively affected by the breach. And that's all. Thank you so much and have a nice day. Bye for now.